Hey out there, legal warriors. Have you ever heard of conditions of release in a criminal matter? Do you want to know why those are important? Why we have to care about them when they get set? And what happens if you get accused of a violation of a condition of release? If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Lynnwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. Now I'm just going to jump right into it. In a criminal case in Washington State, when somebody accused of a crime comes before the court for the first time, the judge is instructed by court rule to set conditions of release on the freedom of the suspect, of the defendant, going forward. So some people wonder, am I going to have to go to jail when I see the judge for the first time? Well, if so, one of those conditions of release would be posting bail. And hopefully, for the most part, we don't get bail set on us, because that's a pretty stiff condition of release. We have to pay some money to a bonding company or to the court to get out. So that's not really what I'm talking about in this video. I'm talking about other conditions of release. And what might those look like, and why might we care about that? Well, let's imagine standard non-felony gross misdemeanors, a DUI. Condition of release might be don't drive without license and insurance, don't consume alcohol or non-prescribed drugs, don't leave the state of Washington. A few courts do that. There's conditions of release like that, and of course the most common is no new crimes. That's the most common one that the court is concerned about. So at the arraignment, your attorney has a chance to argue about what the conditions of release should be. If the prosecutor is out of hand, like wanting an ignition interlock when it's not required, hopefully your attorneys can argue against that. The court can do what it feels necessary to protect the public. The court is supposed to do what's necessary to protect the administration of justice, to protect the public, and to make sure that the defendant or the suspect shows up again in court at future court dates. Other types of conditions of release we have to care about would be in an assault case or a domestic violence case. There we have to worry about no contact orders, because almost certainly in a domestic violence case, the prosecutor is going to ask the court to issue a no contact order, not letting the defendant go home to whoever the supposed victim is, to their home. And oftentimes the alleged victim wants their loved one to come home, right? Sometimes they don't want the court telling them, that their loved one can't see the kids or can't come home. And so there the attorney is going to argue against, hopefully, that condition of release being entered. So it's basically the prosecutor gets to say what they want for conditions of release. The defense gets to argue for other conditions of release. And if you're lucky, you're going to hear the prosecutor say, "Judge, we just want standard conditions of release." And while that's not written in law, for most courts, standard conditions of release would be stay in good contact with your attorney or get an attorney, keep your address updated with the court, appear for all court dates, and don't commit any new crimes. So if it's not a DUI or an assault or something like that, standard conditions of release hopefully are what you're shooting for. So how do they matter? And is anyone checking up on conditions of release? I get asked that a lot by clients at my law firm. And for the most part, for most conditions of release, nobody is going to be checking up on the conditions. There's so much going on in the court, there's not a lot of resources for that. Exceptions might be if you get ordered to do like random breath testing, like the Smart Start device or things like that. Don't consume alcohol with testing. Some courts will actually monitor that if they have a probation department, things like that. So if you run into a problem and you think you might have violated one of those conditions, make sure to tell your attorney so they can figure out what to do. They're likely going to know what typically happens in the court, and will that be a big problem for you or not? The other condition of release that is looked at quite often would be, have you had any new criminal law violations since the date the conditions of release were set? And prosecutors and courts have access to the system where they can see if there's any new allegations against somebody, mainly filed charges, but They can also look at arrests for charges that weren't filed. And your defense attorney may not have access to that same system. It depends. It's pretty complicated, but that's one that's going to be checked on quite often. Things that aren't going to be checked on that often, well, did you leave the state? Well, no one's going to typically know unless you tell them. Again, I want you to obey conditions of release, but this is sort of let you know what's going on. Sometimes a condition of release of not contacting somebody, typically that's not going to be checked on. Again, I want you to obey a condition of release, but I get asked the question, are they tracking me? Are they going to come look at my phone? Probably not, but let's say you reach out to the alleged victim against a condition of release. If someone says you did that, they're going to be able to figure that out by getting a hold of the alleged victim. So again, obey conditions of release. So moving on to what happens if the government knows we violated a condition of release. Well, a couple things could happen. They could, if it's really a bad violation, they could set a hearing early to bring you in and ask that you be put into custody, put into jail for violating that condition. Or what happens more often is at your next regular hearing scheduled, like a pretrial, they've learned that there's an allegation of a violation of conditions, such as, hey, you were supposed to only drive with an ignition interlock device, and we see a record here where you got stopped without one. Or, hey, you weren't supposed to consume alcohol, and the ignition interlock company sent this positive test on your interlock device to the court, and we're mad about that, and we're going to do something about it. We're going to put you in jail for that. So that's what can happen if we violate a condition. And for most parts, and for certainly by law, a violation of a condition of release is not a new crime in and of itself. But if there's actually a no-contact order, a criminal no-contact order, you could have a new crime for violating the order that's also a violation of a condition of release. So what do you end up needing to do if you're afraid there's a violation of condition, or there is and it's going to be heard? Well, you need to talk to your attorney, because there's some mitigating things that we might need to do. Let's say you're accused of drinking and there's going to be no way to say that you didn't. Well, maybe we need to self-report that to a treatment provider so we can up your treatment program before we go to court. So there's a reason why the court may want to leave you out of custody to keep doing, the good things and not the bad things. Additionally, if there's a pretty bad violation of a condition of release and we think you're going to go into custody, well, maybe we need to get a hold of a bonding company right away so we can get you out of jail very quickly so you don't miss any work, you don't miss time with your family, things like that. So if we know there's a violation, we can either argue against it if we don't think it can be proven, or we can try to minimize the consequences by taking actions ahead of court. So again, anything you tell your attorney is confidential as long as no one else is around to hear it. And your attorney will let you know, hopefully, what it is they think you should do if you've violated a condition. And so what's the moral of the story? We want to fight against conditions of release. We want to pay attention to conditions of release. We want to obey conditions of release. And if we violate a condition of release, we want to tell our attorney. We don't want to hide it. That way, your attorney will have the best chance to help you. If you don't have an attorney, get one. So hopefully you found these useful. If so, please like and please subscribe. More people get the help that they need. And more importantly, if you have a legal problem, a criminal matter in Washington State, feel free to reach out to my firm. If we get on board, we'll identify a way forward. We'll listen to what's up with you, and we will also be there for you. Thank you.